Hello, everyone, and welcome to One Civil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today may be the day I earn your subscription. For today's content, we're dealing with Social Security death benefits and their availability to a child who was conceived after their parent had already died. This is the case of Astrue versus Capato. In this case, there was some IVF using some sperm from a parent who had died sometime prior. And now the kids are born. And the question is, well, are they entitled to Social Security death benefits as a result of being a survival of a parent? So we're going to read the case. Let's get started with this. Karen Capato met Robert in 1999. Shortly thereafter, Robert was diagnosed with cancer, and he was told chemotherapy might render him sterile. Because the couple wanted children, Robert put his sperm into a sperm bank where it was frozen and stored. Despite the aggressive regime, Karen and Robert did conceive a child in 2001. Robert's health unfortunately continued to deteriorate in 2001, and he died in Florida where he and Karen resided in 2002. So this is a very short, very sad marriage. They got married in 1999, and within 3 years, he's dead. That's pretty depressing. But a piece of him lives on. So his will, which was based in Florida, named as beneficiaries the son born of his marriage to Karen and 2 children from a previous marriage. The will made no provision for children conceived after his death, although the Capatos had told their lawyer they want future offspring to be placed on par with existing children. Shortly after Robert's death, Karen began in vitro fertilization using husband's sperm. She conceived in January 2003 and gave birth to twins 18 months after her husband's death. Karen claimed survivors' insurance benefits on behalf of the twins. Social Security Administration denied the application, and the U.S. District Court for District of New Jersey affirmed the decision. Yeah, so we've got 2 basic issues here. We're only going to be discussing principally one of them, the SSA, but there is another issue with the will, because the will is ambiguous on this provision, right? It talks about children born as a result of the marriage. Right? Yeah. What is one of the things that terminates a marriage? Yeah. So then now we have an ambiguity in the will. How fun! If we got real dollar bills going on, this is the kind of thing that like soap operas are built around. Right? These kinds of ambiguities. But we're not going to deal with that problem today. We're going to deal with the Social Security Administration because at least we're dealing with some law. So let's deal with the Social Security Administration and see what they have to say. Under the relevant state law, a child born posthumously may inherit through intestate succession only if conceived in the defendant's lifetime. So intestate succession is what you have when you don't have a will. That's called intestate succession. Default rules, right? Wills, of course, can modify them. But these are the default rules. So under the relevant state law, which the will may or may not have modified, then a child counts only if they were conceived during the lifetime of the parents. So now we're still back on that will and what it has to say, but we know what the default rule is in the state. The Court of Appeals for the Third Circuit said that under the appellate court concluded that the undisputed biological children of a deceased wage earner and his widow qualify for survivor benefits without regard to state intestate law. So the Third Circuit Court of Appeals, looking at this situation, says, well, Social Security benefits are a matter of federal law. Fair enough. And therefore, what Florida says, not really necessarily dispositive. So we think as a matter of federal law that these children qualify for benefits. All right, well, what does the Supreme Court have to say about all that? Congress amended the Social Security Act in 1939 to provide a monthly benefit for surviving family members of deceased wage earners. Child insurance benefits are among these Act's protective measures. To resolve this, we must decide whether the twins that were born rank as children within the meaning of the relevant Act's definitional provisions. The word child, we note, is in the law twice. Initially, in the prefatory phrase, the child means, and then immediately thereafter in Section E1, child or legally adopted child, delineating the first of 3 benefit categories. A subsequent provision further addresses the term child, under the heading Determination of Family Status. The relevant law says, in determining whether an applicant is the child of a parent, issuance for the purposes of the subchapter, the Commissioner of Social Security shall apply the intestate law of the insured individual's domicile state. So, yeah, in trying to determine whether or not someone counts as a child, well, the federal law says look to state law and their definitions. And then we, of course, know the definition that Florida had. Has to be conceived within the parent's lifetime. So, yeah, that's what the law seems to require. Defining who is the insured's natural child, the regulations closely track other provisions of law. They state an applicant may qualify for insurance benefits by meeting any of the following conditions. The applicant could inherit insured's personal property as his or her natural child under state inheritance law. The applicant is the insured's natural child, and his or her parents went through a ceremony which would have resulted in a valid marriage between them, except for a legal impediment. Before death, the insured's acknowledged in writing or his or her parentage of applicant was decreed to be the parent or was ordered by a court to provide support, or other evidence shows the insured is the natural father or mother within the meaning of the relevant law. Nothing in the definition that Congress provided, which says the child means child, suggests that Congress understood the word child to refer only to children of married parents. Yeah, by child we mean child. Doesn't say anything about them being married or not. That's fair. The district definition, the dictionary also doesn't provide any support to that conclusion. Moreover, elsewhere in the law, Congress expressly limited category of children to cover offspring of marital unions. So once again, Congress knows how to do this when it wants to. And when it doesn't do something, it suggests they didn't want to. So Congress knows how to limit things to children as a result of marriage, if it is so inclined. If it doesn't want to do that, it doesn't have to do that either. So in this particular situation, we don't have to deal with whether or not it's a child of marriage, which was one of the issues, right? Is this a child of marriage? Well, probably not, because the marriage was over at the time. But yeah, but we don't have to deal with that issue because in this particular definition, it doesn't have that problem. Nor does the relevant law indicate Congress intended biological parentage to be prerequisite to the child status. As Social Security Administration points out in 1939, there was no such thing as a scientifically proven biological relationship between child and father, which is part of the reason that biological appears nowhere between the act. So yeah, not only not children by marriage, but not necessarily even biological children. Because in 1939, proving whether or not someone was a biological child, there was no such real technology in 1939, so Congress probably wasn't speaking to that. Fair enough. We note in answer, the marriage does not ever and always make parentage of child certain, nor does absence of marriage mean it's uncertain. So the court here laying down some red pills says just because you're married doesn't mean that parentage is certain. So Congress probably didn't have that in mind. And it's far from obvious from the other proposed definition, biological children are married, that this would even cover the situation because, as we've noted, the marriage was over. Because death. So even under a proposed definition, it doesn't make any sense that the child would be covered anyway. So you got all kinds of constructs. Resisting the importation of words not found in the statute, child means biological child, which, no. The SSA found a key clue in the statute. In determining whether the applicant is child of an individual for the purposes of this chapter, the commissioner shall apply the state intestate law. So, whatever the state says, The original version of today's statute was similarly drafted. It provided that in determining whether the applicant is the child of an insured individual for the purposes of the section, the board shall apply intestate law. References to the state law to determine status as child is anything but anomalous. The Act commonly refers to state law on matters of family status. For example, the Act defines wife as wife of an insured individual if conditions are satisfied, which would again go to state law. Indeed, as originally enacted, a single provision mandated the use of state intestate law for determining whether this is a wife, widow, child, or parent of a presumed individual. So that would make sense. Go under the relevant state law to make those determinations. Just as the Act generally refers to state law to determine whether an applicant qualifies as wife, widow, husband, or widower, In several sections, the Act sets duration of relationship limitations. The time limits also qualify the state statutes that accord with inheritance rights to posthumously conceive children. So there are time limits also in the statute that accord with time limits put into the relevant state law, and so those are the ones to follow. As we've explained, the statement in Congress's definition that child means child is a definition of scant utility without aid to its neighboring provisions. That aid is supplied by the law, which completes the definition of child for the purpose of the subchapter, and then refers to state law to determine the status of a posthumously conceived child. The state's interpretation of the administration's interpretation of the provisions adhered to without deviation for many decades is reasonable, and therefore under Chevron governs. Tragic circumstances of the death before he and his wife could raise a family give rise to this cause. But the law Congress enacted calls for resolution of the insured benefits by reference to state law. We cannot replace that reference by creating a uniform federal rule that the statute's text does not support. Thus, that brings us to the conclusion of the case between Estrue and Capado. In this case, some people had some children after they were dead. They were conceived after they were dead, which is a particularly neat trick, I suppose. Welcome to modern medicine. And among other issues, they want Social Security benefits. But the relevant law says, well, look to the state law. And under the state law, it says, look to intestate law. And under intestate law, it says they have to be conceived within the lifetime of the parents, which this was not. So, yeah, whatever it might mean for the will, whatever it might mean for other provisions of law, what it means for Social Security benefits is no. So no Social Security benefits, but, you might still be able to get a piece of will. That's a different issue. And that leads us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.